All right, today we are going to be talking about motorcycle injury cases. What really happens in court? Welcome to a new informative segment of Moto Talks with Mitch and Mel for the law firm of Proner and Proner. I'm your host, Mel Maguya. And as often as we can, we will sit down with the personal injury expert himself and writer, Mr. Mitch Proner, a personal injury attorney with over 30 years of experience, here to answer your questions or any interesting topics that you might find useful in the personal injury world. How you doing, Mitch? Good to have you back.
Pretty good. Thank you, Mel. Glad to be back. Glad to present more information to the riders and members of the general public if they're interested in this type of claim after a motorcycle injury case.
Yeah, definitely. And now I don't know if you noticed, but I did ride in today. I changed. I wasn't going to wear my motorcycle gear in here, but I did ride in. I was lucky enough to find a parking spot.
Yeah. So there's a funny dichotomy amongst riding gear for like the different groups of riders.
Yeah.
You'll see sometimes you'll see a guy on a sport bike and he'll have like a $500 helmet,
Yeah.
and I'll be riding like in a tank top and flip flops. And then other times you'll see like a Harley rider, he might have $500 worth of leather, and he's not wearing a helmet at all.
Yeah, it's very interesting. I guess it's just more, it's funny. It is, we wear it to protect ourselves, but it is honestly, it's part of the uniform or costume.
Yeah.
So I guess that's one way of looking at it.
And I gotta say, sometimes when I'm riding and I go by a reflection on a window,
do the same thing.
I'm checking myself out.
I thought it was just me. Whenever I come to a stoplight or a stop sign, you look for a reflection. It's like, oh, okay. You strain your back a little. I was like, I got to suck in. Oh, I thought that was just me. That's hilarious. That's amazing. All right. Well,
this is where we're bad.
Yeah, that's hilarious. All right. Now, before we go on, just a reminder, folks, that if you need to contact us, all consultations are free and confidential. Call us at any time at 1-800-321 1234. So let's go for it before we start talking about our our motorcycle things that we do. All right, so motorcycle injury cases. What really happens in court? So let me open it up, Mitch, with this first portion of it. What actually happens after a rider files a motorcycle accident lawsuit in New York or any other states?
So, well, first of all, the riders might not realize it, but they can hire a lawyer in New York or any state, and the lawyer might not even file the case. Sometimes riders call me up and they say, I don't think my lawyer's doing anything. And I say, well, let me check your case out in the court system. And I have access to the court system. And I go in. And sometimes, well, it looks like your attorney filed suit. He's got an answer in. He's got a motion from the other, and it looks like the attorney's doing some things. Other times, the attorney hasn't filed suit, and he might not be doing anything with the case. So here's what happens. You hire an attorney. You sign a legal agreement called a retainer. Typically, that depends on state law. So every state has their own retainer agreement regulations. So, for example, in Florida, attorneys routinely will sign up a case on a 40% retainer.
Oh, wow.
40% retainer means the lawyer gets 40% and the rider gets 60%. In New York, we have a 1/3 retainer. Meaning the lawyer gets 1/3 and the rider gets 2/3, and it's regulated by state. Now, once you hire that attorney, that doesn't mean he gets the work. He might have his paralegal call you up and say, what are you doing? Are you going to the doctor and everything? But he might not even be getting those medical records. He might be waiting a little while to see what kind of treatment you're getting before he even starts to get those medical records, which he needs to settle the case.
Okay.
And then afterwards, if he can't settle it, only at that time, he might file suit. But by that time, sometimes it's only been a few months where he tried to move the case without filing suit. Other times he might wait a couple years and then he can't settle it and the case is wasted. Now, it also depends on the state. In New York, it's customary on large claims, the lawyers file suit right away. In Connecticut, if a lawyer files suit right away, I file suit right away in Connecticut, and the insurance carrier might say, "What are you doing filing suit? We didn't even have a chance to see if we could settle it." And they're like shocked that you would file suit without making that effort to settle it. In New York, you can settle it early on, even if you filed suit. One thing doesn't necessarily have anything to do with the other. In Connecticut, once you file suit, it goes into a different claims group, it goes to a different attorney, and it could get bogged down. It's just different practice. I've handled cases in over 30 different jurisdictions. So I'm kind of familiar with what happens with these motorcycle cases in different places. And where I'm not familiar, I contact the local attorneys and try and get an idea how my case is going to move. But a lot of times attorneys in different states contact me to find out what they should do. I just came back from a national conference in San Francisco where these are the type of things we were talking about. That being said, once suit is filed, typically the defense firm is going to want to do three things. One, they're going to want to get records in.
Okay.
They're going to want to get records in not just from your treatment for this motorcycle crash. They're going to try and get records in from any time you've seen a doctor, whether it's for a workers' comp claim or a trip and fall, car accident, and the motorcycle accident. And they're going to want to get all those records. There is a computer information database that the insurance carriers share. And that computer information database has all the claims anybody's ever brought where medical treatment was paid for by an insurance company. So if you go to a doctor on your own, the doctor doesn't take insurance, you write him a check, maybe those records didn't make it to an insurance carrier database. But if you had any type of health insurance, whether it's a workers' comp claim or your personal health insurance, they've got a record of it.
Wow.
They're going to want to get the records from all your prior treatment. And the reason they want that is because they want to make sure you're not claiming twice for the same injury.
Oh, wow. Okay. Yeah.
So you're claiming for a broken leg.
Right.
And you're saying there's permanent damage to that leg. Well, had that leg ever been hurt before? For all they know, even though you broke it, you were limping on it for 2 years from another accident or a workers' comp claim. So they're going to want to get the records from that prior treatment. Second thing, once they have all the records in, they're going to want to take a deposition where they're going to try to get a sworn statement about how the collision took place and how you feel you're suffering from your injuries. And maybe, are you lying about prior treatment? Did you have a prior treatment to your leg? No. Did you bring a workers' comp claim in 1978? Oh, yeah, I did. And did you treat for your leg? Yeah, but that just resolved in 2 weeks. Well, didn't you treat with this doctor 2 years later for those injuries? Oh, I don't remember. But that's what they do. Then they'll try and question you about how the accident happened. Did you see the other vehicle? How far away were you when you saw the other vehicle? Did you apply your brakes? How much time passed from when you applied your brakes to the collision? Did you take an evasive? They're going to try and get any statement they can to show the accident was partially your fault. Because if it was partially your fault, they don't owe you full damages. If you go to trial and you get an award for $2 million, and the jury also decided the accident was half your fault, means 50% your fault and 50% theirs, you don't get 2 million. You only get 1 million.
Wow.
Because the accident was half your fault. So they're going to try and get any statement they can incriminate you on liability so they don't have to pay you full damages. The third thing they're going to want to do is have their own doctors examine for any problems that you have that you claim are from this incident. You can't run, but we're going to have our doctor look at you. Now, on top of that, they're going to wait. They're going to wait because they have their money to settle the claim invested.
Right.
And they're making money.
Right.
They're just leaving it in their bank account. They're getting interest on it. If you go to any bank in the country and you say, if I leave $100,000 here for a year, how much money will I get? I'll say, oh, you'll get $4,000. And if I take the 100,000 out after a week, oh, then you don't get anything. So that $100,000 that they put aside to settle your case, if they could hold on to it for a year, they just made 4,000. So they paid you 96.
Yeah.
Right?
Yeah.
So they want to wait. Now, that being said, an attorney has different tools they could use. One, they can make a motion for summary judgment on liability. And if they win that motion, they could get 9% interest if the case settles. I'm sorry, if the case doesn't settle and goes to trial, they could get 9% interest. But if there's only 100,000 in coverage, the insurance carrier's not going to pay over that anyway. But maybe they're tying up their lawyers, and that costs them money. And that might create some leverage to move the case. Ultimately, if the case doesn't settle, there are numerous conferences where a judge is going to try and get the case to settle. And the reason why judges have an interest in moving the case to settle is because judges are graded not just on how well they write decisions, but on how well they move their caseload. The cases come into a court system, and the judges have to pay attention. If there's a motion on it, they have to deal with the motion. If there's a conference, they have to be there for the conference. And if there's a trial, they might have to sit with that case during the trial for a month and a half.
Wow.
Listening to witnesses and everything else. Well, if the case settles, they don't tie up their courtroom for a month and a half. They don't tie up their attorneys, because judges have attorneys that work for them, court clerks and law secretaries that are actually attorneys, that are their staff. They don't tie up their staff dealing with motions. If they move a case, and the higher courts look for dispositions. So a judge who gets a lot of dispositions on their cases, they move their caseload. The administrative judges obviously like that. A judge that can't move their caseload, the administrative judges say, hey, all the other judges are moving their cases. Why aren't your cases moving? So the judges want to settle cases. They don't want to tie up the courtroom trying up cases. But every judge has a different disposition.
Wow.
And that's typically what goes on. If your case goes to trial, jury selection, and in some parts, the client is there for jury selection, and in other parts, it's customary the clients aren't there. It's just the attorneys.
Oh, wow. Okay.
So if you try a case in the city and the suburbs, typically the clients aren't there during jury selection.
Yeah.
If you go upstate and you go to pick a jury, There'll be a judge that says, "Where's your client?" And that's just the way it is. So the attorney's got to know where he is, and usually a smart attorney, after a little while, learns I better find out the local rules. And young attorneys, they want to show up and make like they know everything because they're embarrassed to ask questions. Once you get a little more experience, you know what you're doing, and you can show up and say, "Hey, how do you run this part here?"
Well, thank goodness you do have that experience. So let me just you already kind of touched on the whether crash case settle out of court and what have you or end up in jury. But if you don't mind, I'm going to move on to the other section here on. So like, because I know I want to know this, but on the day you appear in court, what should riders or just anyone expect? Like from jury selection to telling your story under oath, like what can like especially for someone I've never had to go, knock on wood. So what could I expect?
So typically, the first time a client might appear on their case would be at a deposition. And at a deposition, first of all, the client should expect to be prepared. Now, not every client has the benefit of a law firm that prepares their clients. So, for example, there's a firm out there that calls themselves the biggest law firm. Bigger is better. And that firm has a problem, at least in New York, with turnover. They have a problem keeping attorneys.
Wow. Okay.
And they might have a young attorney there that he or she might try to prepare the client. They don't even know how to prepare a client because they haven't been practicing that long. And that's who's assigned to your case. You don't get to say, no, I've interviewed that one. I want to interview another one. Give me, you're such a big firm. Let me interview 6 of your attorneys and I'll decide who I want.
Yeah.
It doesn't work like that. An attorney's assigned to your case. And but even a smaller firm might be say, I do real estate, I do closings, I do divorce, and I do personal injury. Oh, I know about personal injury. But if you don't do it all the time, you might not know all the issues that might come up as you would with a firm that's run by an experienced trial lawyer like me. Anyway, and people sometimes come to my office and they want me to take over the case, and they say, my attorney didn't prepare me for anything. You have a right to be prepared. You should never give a statement under oath without having some preparation with an attorney. Now, that being said, it's hard. Oftentimes, it's a long day questioning. And the insurance carriers, they have attorneys that ask these questions all the time, whereas the rider doesn't answer these questions all the time.
Mm-hmm.
They may have never given answers under oath in their life, and they might get tired.
Yeah.
And they might feel comfortable just saying, I don't know. I don't know. I don't know, because they're tired.
Yeah.
But those I don't know answers aren't the best. Ultimately, I tell my clients, you want to seem like the type of person that somebody would trust to hold their money. Now, if you have somebody that says the accident happened on Tuesday, March 8th, 2023, happened at approximately 11 o'clock in the morning. I was on my way to my mother's house. I left my apartment at approximately 9:30. I got on my motorcycle. I started out on Boyland Drive. That's Boyland Drive. I went approximately 2 miles. I made a right onto High Point Street. High Point Street is a two-way road, WL line, etc. Or somebody that says, I don't know,
Yeah.
Sure where I was coming from. I don't remember. And where are you going? I don't remember where I was going. At what time did you leave? It was the morning. Around what time? I don't remember. And which one would you want to give your money to hold?
Yeah.
Of
I
course,
agree. The one that's more prepared.
he or she seems like she's got the facts. She knows
Yeah.
what's going on. She's aware of what happens. And because if somebody sounds like, I don't know, then maybe when they were riding their bike, they weren't paying attention either.
So you're essentially like training, not training is the wrong word, but you're giving them a script that or an outline so that they know the cleanest, most efficient way to
Actually,
talk to them.
actually, training was a better description,
Ah, okay.
giving them a script.
Yeah, okay.
And I'll tell you why. The client should recall the facts. The client should recall the facts. If I tell them what they recall, maybe that's fraud, right?
Right.
Is that what happened, or is that what your lawyer told you to say?
Ah, okay.
No, I don't remember what happened. This is what my lawyer said I should say. Does that sound
Ah,
does that
okay.
sound like ethical?
No, yeah, I see what you're saying. Wait, so how much time are they given
Let's
though?
suppose, hold on a second. Let's suppose my office was bugged,
Mm,
and I'm telling clients, no, I don't care if you think you were doing 20 miles an hour, you were doing 15. You got to say you were doing 15, but I was really doing 20. No, you got to say you were doing 15. I
mm.
said, okay, I'm doing 15. Well, that sounds like fraud, right?
Yeah, yeah, yeah.
Okay. You don't need to do that to win. It's not necessary. Any lawyer that thinks that they need to practice law like that is a fool.
Mm,
I win my cases on a regular basis, which is why attorneys around the country try to ask me how I do it. I lecture around the country to attorney groups regularly, and I do it ethically. Now, I'm entitled to prepare my clients with the evidence in the case.
okay.
So if somebody says to me, when did you go? If I say to my client, when did you go to Dr. Smith? And they say, I don't know. And I say, well, his medical records show that you went there March 2nd, 1994. Does that refresh your recollection? Yeah, now I remember it was March. That's fine. You're entitled to refresh your client's recollection with anything,
Mm,
as long as it's not like some fantasy that you invented, right? I can then, if I see a video of my client, because we went and got surveillance video from a gas station close by where the accident happened, and my client says he was driving a green car. And I said, look at the video. My client says, oh my goodness, that's clearly a red car.
mm.
Does that refresh your recollection? Yeah, now I remember it was a red car. I don't know what made me think it was green. I must have been thinking, I mean, that doesn't seem to be improper to show them. And then if the client's asked, did you see anything? Yeah, I looked at a video of the accident scene before I testified here today. It's okay.
Ah,
Nobody's going to say, oh, well, he shouldn't be allowed to look at a video of what happened before he testified. No, he saw the video. That's going to be evidence in the case.
okay.
So if you know something is going to be proof and produce the case. Now, the other thing that I can do is before they testify, we're entitled to go to the accident scene and look at it. And if they say, did you ever go back to the accident scene? Yeah, I went back to the accident. I looked it over. Had it changed since the accident? No, looked the same. How many lanes of traffic were there? I could ask you, and you come to work here all the time, right?
Mm-hmm.
How many lanes are there on Lexington Avenue?
4?
Right?
Was I right?
No.
Look at the window. What
You know,
was?
but that's the point, right?
Yeah, yeah,
Now, if you went there, right?
yeah.
You walked outside and you saw, yeah, okay, it's 5 lanes. All right, 5 lanes. And like, is it any different than it always was? No, it's the same it always was. I just never really
Yeah.
counted. Right? So they say, how many lanes were there? Now you might know I was the second lane from the right. Okay. And how many lanes are there? There are 5. That's not unethical. But a client should be prepared ethically, and then they typically will be a better witness. Now, there's some things and some clients, they have a hard time. So I might go to trial, and this happens frequently, not infrequently. Frequently it happens. The first question I say to my client is, tell me about your education and work experience, because the client's introducing themselves to the jury.
Mm.
Now, it's their life, right? But some clients, what year did you graduate high school? 81, 82, 79, 83? I don't remember. And I say, well, let's figure it out. Did you get left back? No. Did you skip a grade? No. Do you know how old you were when you started school? 5. Okay. And when you finish, you're 18? Yeah. You graduated in 1981. Oh, yeah, that's right, because I entered the service in 82, right after I graduated. Okay, yeah, that's right, 82. So you graduated in 81. Okay. What high school did you graduate from? North Hills. Okay, so let's start off with, I graduated North Hills High School in 1981. And then you went into the service. Yeah. And when did you go in the service? 82. What branch of the service? Marines. And how long did you serve? 3 years. What year did you get out? I don't know. Well, you graduated in 82. You did 3 years. Could you gotten out in 85? Yeah, 85, because that's when I got my union card. It was 85, and I got my union right after I got out of the service. Okay. So, all right, so let's just do that part all over. So I went to high school, and then I went into the service. No. Give me the year and the name. All right. So I went to high school, and I graduated in 1979. No, we just decided it was 81. And I'm telling you. And they're like, well, this is easy for you. You remember this. And I'm like, this is your life. This is your life. And they're like, ah. And they're like, can we take a break? And I'm like, damn, I just got through just high school.
So essentially, that's what you're doing is like you're giving them kind of what could
Like
potentially
I
happen
said,
in
I'm
court.
training them,
Yeah, yeah,
but I'm training them to answer questions,
yeah,
right? But some people have a hard time just remembering things,
yeah.
and they can be really smart, really accomplished. Ultimately, I became lead mechanic for Grummond. And how many mechanics did you have underneath you? 2,000. And it's like, damn, this guy had 2,000 mechanics working for him at Grummond, and he can't seem to remember what year he graduated high school. And you think that like,
Yeah.
oh, that doesn't happen. I'm saying this happens on every case.
Yeah.
It happens on every case, and I got to. And it's not like I'm trying to say to them, no, you got to say the other vehicle was speeding. He goes, no, but it was going the speed limit. No, it was speeding. That's fraud.
Yeah.
I'm not engaging in fraud. I'm just trying to get them to be comfortable providing information to the jury. So let's start off with the jury gets to know a little bit about who you are, because they're going to want to know, right? You ever see a movie where, like, you watch the movie and you're like, wait a minute, who is this guy? Is that his son? Is that his son? What's their relation? And you're like 15 minutes in thinking, you're like, no, it's not his son. Well, did he work for him? Have you ever had that happen to you? Because you're trying to figure out
Yeah.
the story, however he's related. And
Yeah.
everything else.
And you're not paying attention to what's happening because you're trying to think.
Well, the jury's the same way. They want to know, who is
Yeah.
this guy, right? You know, well, why was he on the bike there that day? Where was he doing? Where's he coming from? Where's he going? They want to know that, right? And you want the guy to be able to tell the story in a coherent fashion. You don't want to get the client on the stand and just be like, I don't know. No, I don't. And other people, by the way, some people are just, they get it all. They get it all. And then some people, they try to make their case better, even though they don't need to. Like I was practicing early on. It was a case, and they said to my client, do your injuries bother you at all? And he says, yeah, they bother me when I do karate. And the guy says, how often do you do karate? And the guy says, just about every day. And it's like, well, what sort of karate moves does this bother you on? Well, I do push-ups on my knuckles and my shoulders hurt when I do that. And I do, and it's going on. And I'm like, what's the name of, and the guy says, did you have a class that you belong to? And he's like, yeah, I belong to a class. What's the name of the school? The guy's like, well, I'm not sure because I changed schools. Okay, well, what's the name of the school you used to go to? That one was by my house. Well, what was the name of it? You know, it's got like a sign in Chinese. I don't remember. And like after the deposition, I'm like, what was all this karate stuff? Where'd that come from? And the guy goes, I wanted to make the case better. Did I do it? I'm like, no, you're an idiot.
Oh man.
These things happen.
Yeah.
You gotta, but as an experienced attorney, now I know, stick to the truth. Stick to the story. Story's a good story. Just, we'll win with that. And so that's a lot of times just by having a good story, which is the real story.
Yeah.
You're more likely to get justice.
Yeah.
And justice for a motorcycle injured client means more money.
Yeah.
And you get more money just by just telling the truth and remembering what happened than by just making things up and not knowing anything. And that's a big part about having the right lawyer, somebody who knows what they're doing and is willing to spend some time with you and time with the claim and get what's fair.
Yeah. And you are definitely that person. Well, you know what, Mitch, I think we went a little off topic, but it was actually very entertaining because I mean, you really did actually answer a lot of my questions, and I'm sure there are gonna be people out there who are thinking the same thing too. Because I mean, it's about being comfortable. It's about not.
Let me wrap up with the topic.
Yeah, please.
Okay, so first,
yeah, please.
When you go to court, a lot of times because you're in a motorcycle crash, they try to discount the value, and when you ask for a number, the judge who's trying to get a settlement will say, everybody hates motorcyclists. They're going to blame your client. You better take less. And if you have a lawyer who doesn't try a lot of motorcycle cases, he might be saying to you, I got top dollar on this case, motorcycle. You don't know you got less than you should have.
Yeah.
And having that reputation to try these cases, I think increases the settlement value on all your cases. And fortunately, I have that reputation. Things got easier for me once I did get my reputation. But they're going to try and discount your case. And if you feel your attorney's discounting your case, that's a problem.
Mm.
Okay. Second of all, your first time in court's for your deposition. The second time in court might be a trial. And you better prepare. And you better have an attorney that's willing to prepare. And if you don't feel prepared, something's wrong. Third of all, you need to have the evidence to prove your case. And that typically comes from the doctors. And if you're not getting treatment for the injuries and they're still bothering you, you better go back to the doctor and tell them they're still bothering you. Two things will happen. First of all, the doctor might provide some treatment that makes you well or gives you comfort. They might say, get some physical therapy. We need to do an operation, get some medicine. You know, I went to the dentist the other day, and he said, we might need to do root canal. I said, I'm not doing root canal. I'll just chew on the other side. And he said to me, you can't do that. Now, doesn't mean I got to get the root canal tomorrow, but maybe if I'm going to keep my teeth, I eventually have to get it. I don't know. But you might need a surgery. And that might affect your whole life. The way you walk, the way you carry things when you're 60 or 80. You might need to get that procedure. I don't know what your condition is, but at least you can get informed. You might just need physical therapy. You might need some medication. The physical therapy might do it, and you don't need the surgery. But the second thing it's going to do, in addition to the doctor maybe providing some comfort, is you're going to get proof for your case. It becomes admissible evidence that can be used to get you the money you deserve. So your lawyer should be a lawyer that you trust is going to do the right thing for you in court, even when you're not there. When you have to appear in court, you should feel comfortable and prepared to the extent that's possible. And other than that, I hope you get the justice you deserve.
Amazing, Mitch. Thank you so much for that. I mean, honestly, it's a great insight, just to prepare anyone for if they have to go to court. And thank goodness you are the right person for, especially for motorcyclists. Well, there you have it, folks. You heard it from the expert himself, Mr. Mitch Proner. And don't forget, if you need our help, please give us a call at 24/7 at 1-800-321-1234, where consultations are free and confidential. That'll do it for now. And thanks for taking your time to tune in, whether it's on our podcast or video broadcast. We really do appreciate you taking the time. And please, if you haven't yet, follow us on Instagram, TikTok, Facebook, and of course, YouTube. And of course, don't forget to like, share, and please subscribe so you get all the latest updates. And yeah, I normally say, is there anything else you want to add, Mitch? But please, I still will. Wait, what was that?
I said, thank you.
You're welcome. Well, that's it for now,
Yeah.
Mitch. Thanks for another informative session with you. And thank you all for checking us out. And remember, we ride just like you. So we'll see you next time. Thanks, Mitch.
Be well.